Welcome back. You all will recall, I'm sure, that at common law, in a civil court, the death of a human being could not be complained of as an injury. The historical basis for this rule in England was the so-called felony merger doctrine, which denied a civil action for damages when conduct by the defendant was both tortious and criminal. The theory behind this doctrine was that the felony action was more important to society, and the felony action, as a practical matter, preempted the civil action. Both intentional and negligent homicide were felonious, and the criminal punishment at the time was death and forfeiture of all assets to the Crown. So if the defendant was convicted, there were no assets for the plaintiff to recover. Well, early Californian decisions, like decisions in virtually all other states, followed the English common law and held that there was no action at common law for wrongful death. That common law rule was recognized as unjust and unwise for at least the following reasons. First, the rule created the well-recognized irony that the defendant was better off if the plaintiff died than if the plaintiff survived. Second, if, as happened in many cases, the plaintiff died only after having been treated for his injuries, the plaintiff's estate might be forced to foot the bill. Moreover, if the plaintiff had lived, he would have recovered damages for any lost wages, and those members of his family who relied upon him for support would thus indirectly have benefited from a recovery. But if there's no cause of action because the plaintiff dies, the family members are going to be denied the support that otherwise they would have been entitled to. Dissatisfaction with the common law rule led to the enactment of statutes allowing a civil action, even though the injury complained of was death. The first such statute was Lord Campbell's Act in England in 1846. And every state in the United States has now enacted statutes abrogating the common law rule, and Congress has enacted federal counterparts. Two types of statutes were enacted to remedy the shortcomings of the common law. First, wrongful death statutes provided that heirs were entitled to recover damages for the loss of support that resulted from the decedent's premature death. Second, survival statutes provided that any cause of action for damages that existed at the time of the decedent's death passed as property to the decedent's estate. The cause of action was not extinguished because of the death. Well, let's start with wrongful death statutes. California first enacted a wrongful death statute in 1862. The cause of action for wrongful death is now provided for in Section 377 of the California Code of Civil Procedure, which provides that when the death of a person is caused by the wrongful act or neglect of another, his or her heirs or personal representatives on their behalf may maintain an action for damages against the person causing the death. In every action under this section, such damages may be given as under all the circumstances of the case may be just. An action for wrongful death in California must be brought by or on behalf of all the heirs. An action by some, but not all of the heirs, is not an action authorized by the statute and is subject to dismissal. If there are no heirs, there can be no cause of action. Thus, an administrator of the estate cannot bring the cause of action solely to benefit the estate. Section 377 creates a cause of action for wrongful death when the death of a person is caused by the wrongful act or neglect of the defendant. Wrongful act or neglect includes intentional torts and negligence, and it's been used in product liability actions and even breach of warranty actions. Wrongful act or neglect does not include, however, a mere breach of contract. The reason is that the wrongful death statute is designed as a tort remedy and not as a contract remedy. If the only conduct by the defendant is a breach of contract and the breach does not give rise to an action in tort for damages, then the wrongful death statute should not be interpreted to create a tort cause of action in that circumstance. Prior to the adoption of comparative fault in California, the decedent's contributory negligence barred the action for wrongful death in its entirety. In actions now arising after the adoption of comparative fault, the decedent's negligence simply reduces the amount of recovery in proportion to the decedent's relative fault. Of course, even after the adoption of comparative fault, if the decedent's negligence is a superseding cause of the injury leading to death, no action for wrongful death will lie. The action for wrongful death is designed to benefit heirs who would have received continued support from the decedent but for the decedent's death. In accord with its underlying purpose, damages have generally been limited to the following: past and future financial support that heirs would have received from decedent, loss of society, comfort, protection, love, companionship, affection, sexual relations, and the like, and funeral expenses. The action for wrongful death should be thought of as derivative in nature. The heirs are being permitted to recover damages because of a breach of duty with respect to the decedent, not because of a breach of duty with respect to the heirs. Accordingly, courts have denied heirs the right to recover damages for their own mental and emotional distress, including grief and sorrow. On the other hand, if the defendant independently owed a duty of care to one of the heirs, well, that heir may recover for emotional distress. That situation can arise when the heir is present at the scene of the accident and suffers severe emotional distress from witnessing the death. As you will recall, these are the bystander cases, where an heir who witnesses the death may, in an appropriate case, recover damages for his mental distress. Let's now turn to the survival cause of action. California originally followed the common law rule that actions for personal injury or death did not survive the death of either the injured person or the tortfeasor. Wrongful death statute solved the problem insofar as heirs were concerned, but the wrongful death statute did not deal with the problem of medical bills and such that were incurred prior to the decedent's death, bills that burdened the estate. And if the tortfeasor died, persons who had been injured by the tortfeasor were left holding the bag, since there was no suit against the estate. Ultimately, the California legislature finally acted in 1961 to make all actions survive the death of either the victim or the tortfeasor. Survival of actions is now provided for in Section 573 of the Probate Code. Section B deals with suits brought against a tortfeasor who dies, and it provides as follows. In an action brought under this section against a personal representative, all damages may be awarded which might have been recovered against the decedent had the decedent lived, except damages awardable under Section 3294 of the Civil Code, that means punitive damages. Section C deals with suits brought by the estate of a decedent against his or her tortfeasors, and it provides as follows. Where a person having a cause of action dies before judgment, the damages recoverable by his or her personal representative are limited to the loss or damage the decedent sustained or incurred prior to death, including any penalties or punitive or exemplary damages that the decedent would have been entitled to recover had the decedent lived, but not including damages for pain, suffering, or disfigurement. Those emotional distress damages are viewed as personal to the decedent and therefore not recoverable by the estate. As you can see, the basic notion is that with just a few adjustments for punitive damages in the case of a suit against an estate, and emotional distress in the case of a suit by the estate, the death of the tortfeasor or the victim does not change the right to recover damages. Well, that's it for this chapter. I'll see you all in class.